Good morning. It's 10 o'clock, and obviously we're here for Countryside's Right of Way panel. Could I thank all that have attended for a start, and welcome County Councillor Mike Worthington, who's here for item number 6. We'll start off, please, with apologies.
Yeah, good morning, Chairman. We've received apologies today from Councillor Abrahams and Councillor Snape.
Thank you. Any other apologies? That's everyone. Yeah, great. Okay. And could I ask councillors here, have they got any declarations of interest in accordance with Standing Order 16.2? No. Okay. And we'll move on to the minutes held on the 17th of September 2021. Have we got move from David? Jill? Okay, so we'll move the minutes. Could I just at this point say that we had a letter from a member of the public which was actually complimentary, and we don't get many of them. But this person did say, and it'll remain anonymous, that it was a pleasure to see how well the officers and members conducted the meeting. So thank you all very much. And I hope that goes back to the office as well for the rest of the officers that involved. And so we've passed the minutes. And we'll move on to item number 4, please, which is the Wildlife and Countryside Act 1981, application for an alleged public footpath from Jolpool Lane near Hardwick Grove to the B5027 near White House Lane, Sandon.
Thank you, Chair. Thank you, Chair. The application that you have before you was submitted by Mr. Ray, alleging that there's a public footpath from Jolpool Lane to Sandon. The lines of the footpath are shown on Appendix A, marked A to B. The applicant submitted a paucity of evidence to some extent. He submitted the 1910 Finance Act map and the extract from the Book of Reference, and also a copy of the parish survey undertaken under the 1949 Countryside Act for the Sandon area, and a copy of the 1954 draft definitive map. The landowners have said that they have been a tenant and that during their period they've never been aware of any public right-of-way crossing the land. I have to point out that they also haven't been aware of anybody using the land either. The evidence, the Finance Act, it shows that the tax relief was granted. If members examine the maps, you'll see that there's a public footpath that crossed over plot 44 and plot 63. In the corresponding field book, relief was given to the value of £10 for plot 63 and £20 for plot 44. It was therefore apparent to the valuer at that point in time that a public highway existed across the land with the status of footpath. Otherwise, he wouldn't have given tax relief. And it was quite a hefty fine if a landowner made a false claim, and it was subsequently found not to be upheld. In fact, some landowners during the Finance Act surveys didn't claim anything because they were, one, not desirous of public footpaths or rights of way across their land, and two, because of the case that they might make a false declaration. So the mere fact that the landowner does, and the valuer agrees with him, suggests that it's significant enough to attract the tax relief. Mr. Ray also submitted the parish survey for Sandon. It has an entry for a path labelled footpath 26. And the grounds for believing it to be a public right-of-way are usage. The applicant suggests that this is the exact same route. The evidential weight of the survey varies dependent upon what was put in it, but it did form the basis for the 1950s definitive map, draft definitive map, from which landowners, members of the public could object either to the inclusion, the omission, the status, or whatever it may be. And there were an enormous amount of objections received to those draft maps, when eventually they didn't become definitive until around about 1965. So it took some time to hear all the objections, etc. In this instance, an objection was made by the Earl of Harrowby, stating that it wasn't shown on their estate map. And then after that, it disappears from the definitive map. One could say that it had resulted in a hearing and that the councillors who held that hearing decided to omit it. Or it could be that it was simply as a consequence of administrative work, it was decided it wasn't enough evidence to put it on. It could have been that there were correspondence between the parish council and the county council over it, and it was simply dropped off. For whatever reason, and we have no records to show what the reason was, it was omitted from the definitive map. The survey card alleges usage, quite well-known usage, and yet the landowner, well, the tenant, does say that they've never seen anybody using it, essentially. So we have the Finance Act, and we have the parish survey card. And beyond that, there is nothing else. There is no usage or anything to refer to. So it's basically just down to those two pieces of evidence. The test that one has to consider is the twofold one. Whether or not, on the balance of probabilities, it can be shown that a public highway exists or subsists. In this instance, it's quite clear that the evidence isn't enough to pass that test. It's not enough to say it's more likely than not that a public highway exists. When you come to the second part of the test, which is whether or not it's reasonable to allege that a public highway exists, that is satisfied because, as the courts have said, if you have evidence that suggests a public right-of-way exists and you have nothing contrary to it, nothing to say that that evidence is mistaken or wrong, then you ought to make the order based on reasonable allegation and let it be tested in the public arena. That is the case here. It's no chance of it meeting the balance of probabilities test. So, officer's recommendation is that we make an order based upon reasonable allegation. And that's the recommendation, Joe.
Okay. Thank you for that. Before we debate this or throw this open to debate, has there been any recommendation or acknowledgement of this from the local member, who's Ian Parry?
No, Joe.
Okay, and you, Rebecca, who've authorised the report, who's done the report. Thank you for that, and thank you for bringing it to us. Okay, any thoughts? It does seem fairly sort of clear to me, but...
Chairman, I'm happy to move I'm happy to move the recommendation, Chairman.
Thank you, David. Jill?
I'll second that.
Okay, so hands shown on that. Okay, so that has moved as recommended by the officers. Thank you for that. We'll now move on to item number 5, which is an application for an alleged public footpath between Western Road and Tixall Road, Stafford. I don't know who's taking this one. David, thank you.
Thank you, Mr. Chairman, members of the panel. First of all, can I say that we have received no representations or objections from the local member. This is an application made by Mr. Derek Arthur Luker and Miss Pamela Luker in 1996. It was made as a joint application. It is an application for the addition of an alleged public footpath between Western Road and Tixall Road, Stafford. Moving straight to the recommendation, your officers feel that the evidence is sufficient to show that the public footpath can be reasonably alleged to subsist along the route marked A to B on the plan attached as Appendix B in the pack, and that an order should be made to add the route to the definitive map and statement for the Borough of Stafford. This application is based on user evidence. The applicant submitted 18 user evidence forms, which you can find at Appendix C. Only one landowner has been identified, being Stafford Borough Council, the sole freehold landowner in this case. We did have a response from 2 of the statutory consultees, Hopton and Coton Parish Council and the Ramblers Association. Both strongly supported the application, as you will see at points 11 and 12 of the report. And again, you will find these at Appendix G. Your officers did pursue the matter further and examine various Ordnance Survey maps, the line of which some may have interpreted to be a path. This, however, was later shown to relate more properly to a nearby watercourse, which can be seen by comparing the colour plan at Appendix B with the OS maps at Appendix F. Taking the user evidence forms together, it became apparent that the relevant 20-year period for this application would be from 1976 to 1996. There was no challenge to use, and so this relevant period was calculated backwards from the date of application, being 1996. Of the 18 users who supplied user evidence forms, a total of 12 had used the route throughout the relevant 20-year period. 4 of these had done so on a very regular basis, daily, weekly, or once or twice a day, constituting a third of the relevant users. Of the remaining 6 users who did not use the route throughout the relevant 20-year period, 2 of them can be combined together to make another complete user. You will see at point 25 of the report how we arrived at this additional user, resulting from the combined evidence of the Misters Mosley and Middleton. This gives us a maximum figure of 13 users for the entire relevant period, which, being over half, gives significant weight to the application. The report then goes on to talk about the width of the alleged route from points 27 to 30, and although not material to the claim itself, this gives us guidance at a later stage should an order be considered. As you will see, there were some references to stiles and gates on the route, although these were not significant enough or material enough to require the use of force to navigate them. Again, we can safely show that the use was therefore without force. Most of the relevant users were accessing the route on foot. I think we have a figure of 10 out of the 12 who testified in this respect. This would support the contention that there are no higher rights than those of a public footpath. Your officers recorded at point 40 of the report that there was some minimal reference to bicycles using the route. This would emphasise the fact that the stile and gates referred to earlier were clearly not an obstruction, that is, a material obstruction that required any degree of force to overcome. Turning to the reasons that people were using the alleged route, we can see a dominance of pleasure use over business or work use. I think that 9 users stated pleasure use and only 1 was using the route for work purposes. Considering points 46 to 48, there was some intimation in the evidence that the last few yards of the route may have changed over time. The reference to this, however, was minimal, and without further exposition of this point, little more can be said of it. Nothing turns on this. The line of the route is consistent throughout the application. You can see this further highlighted at point 49 of the report and at Appendix H. Turning to the landowner response form submitted by Staffordshire Borough Council, it can be seen that they never gave any permissions to use the route, supporting the notion that its use was as of right. Nor did they ever erect any signage on the route or ever challenge anyone using the route. Most significant of all is that the landowner stated they believed the route to be public. At point 55 of the report, your officers contend that if the landowner believed the route was public, then he would not have taken steps to prevent its use. Point 56 is also important as it states that it is not the opinion of the landowner that is important, rather the actions or non-actions that result from that opinion. By his actions, therefore, the landowner could be said to have intended to dedicate the route to public use, and that this use had been accepted by the public. The case law does not set out a minimum level of user in any claim, or indeed the amount of usage, although this does have to be enough to bring home to a reasonable landowner that the public are using a way and that the use is as if it were a public highway, as of right. At point 60 of the report, we can see that the user evidence form has testified to many years' usage throughout the 20-year relevant period. The amount of user evidence that spans the relevant period is 67% of the total evidence submitted. This rises to 78% when the combined usage is also taken into account. Clearly, the usage, which was mostly weekly throughout the relevant period, is significant and enough to bring this home to the attention of the landowner. In summation, the totality of evidence suggests that the use of the alleged route has been without secrecy, force or permission, as of right, and with a significant number of users throughout the relevant period. Taken together with the landowner's submission stating that he believed the route to be public, then an intention to dedicate the route is also plausible. Regarding the burden and standard of proof, the alleged route is an addition and as such will be considered under the test of reasonable allegation. That is to say, whether a reasonable person could reasonably allege a right-of-way subsists, having considered all the relevant evidence available to them. The evidence necessary to establish that a right-of-way is reasonably alleged to subsist over land must be less than which is necessary to establish a right-of-way does subsist. The application is made under Section 53 of the 1981 Act, and all points appear to be satisfied in this case. There is a way over land, the character of that land does not prohibit its use by statute, it has been enjoyed by the public and in sufficient numbers over a sufficient period of time, and it has been used without secrecy, force or permission. In conclusion, and in light of the evidence set out in the report, it is your officer's opinion that a right-of-way is reasonably alleged to subsist. It is the opinion of your officers that the County Council should make a modification order to add the public footpath, which is the subject of this application, to the definitive map and statement for the Borough of Stafford. Given that the width has been stated as being between 2 and 6 feet throughout the application, with an apparent predilection for 5 to 6 feet, it is recommended that it is made to a recognised width of 5 foot 11 inches or 5.91 feet, which is approximately 1.8 metres throughout its length. Thank you, Mr. Chairman. Happy to take any questions.
Can I just clarify? I have received correspondence from the local member just to say that she's in agreement with the recommendations.
Excellent. Okay. Any thoughts from councillors? It seems fairly cut and dried to me.
Chairman, I was only looking at it from the map point of view, and it seems to me like it's one of those obvious walkways that would have existed for a very considerable length of time. And so perhaps slightly surprised that it's come to the meeting at this stage that it wasn't already recognised as a footpath. So I've no question but to support the official recommendation.
Sorry, is that a proposal, David? Yes, Jill?
Yes, I would support the recommendation, thank you.
Okay, and as I agree as well, because it's fairly one of our most cut and dried ones we've had for a long time. So we all agree, and the recommendation has been passed. Thank you for the clarity and in your presentation. Now, the next one, which is item 6, is an application for an alleged public footpath at the rear of Ox Pastures, Cheddleton. And I understand that Hannah's going to present this one. It's your first time. Would you like to just quickly introduce yourself and then go forwards with the presentation?
Yep, of course, Chair. So I've been working at the County Council now for approximately 12 months, dealing with rights of way matters. And as said, this is my first report presenting at panel.
Thank you. And relax and go for it. Thank you very much.
Thank you, Chair. So this is an application for the addition of a public footpath at the rear of Ox Pasture in Cheddleton. The line of the alleged route can be seen marked A to B at Appendix B, connecting from Ostlers Lane to the west and public footpath 1R/2575 to the east. The application was submitted by Cheddleton Parish Council, and a copy of the application is attached at Appendix A. The application is based on user evidence, and in support of their application, Cheddleton Parish Council submitted 24 user evidence forms, all from members of the public claiming to have used the way for varying periods of time. Copies of these forms can be seen at Appendix C, with a summary of the main points from the forms attached at Appendix D. In order for the application to be successful, it needs to be shown that the public have used the alleged route as of right and without interruption for a period of at least 20 years prior to the status of the route being brought into question, or that it can be inferred from the landowner's conduct that he had dedicated the route as a public right-of-way and the public accepted this. So in order for the right of the public to be brought into question, the right must be challenged in some way that is obvious to the public that their right to use the way is being challenged, so for example, such as a physical obstruction. In this case, there doesn't appear to be a specific event that took place that brought use of the route into question. And where this is the case, Section 31(7)(b) of the Highways Act 1980 provides that the date of a modification order under Section 53 can be used as the date at which the public's use was brought into question. Therefore, as the date of the application was the 24th of October 1995, this is the date of challenge, and therefore the requisite 20-year period is calculated retrospectively from this date. Therefore, the relevant 20-year period is from 1975 to 1995. Of the 24 users who have provided evidence, 13 of those users record 20 years or plus use of the route within the relevant 20-year period. Four other users have also provided evidence of use from 1977 to 1995, and when this is combined, this does make another 20-year period. As 2 or more users' evidence of usage which overlaps can be added together to produce a cumulative effect of usage over the 20-year period. So therefore, it could be said that 14 users have used the route uninterrupted for the relevant 20-year period. One owner has claimed to own land affected by the route, but on closer investigation, there was no evidence that they did own land affected by the application. The owner lived in Ostlers Lane, which is situated near to the alleged route. Therefore, it can be said none of the people claiming to use the route were owners or tenants of the land affected by the route. A number of users claim that the route is used by parents and children going to and from the local school. One user did make reference to a gate, but on closer inspection, this did not appear to affect the alleged route. No other users have made reference to any gates or any obstructions along the alleged route. The frequency of use of the route does vary, but 11 users do claim to use it weekly, 3 users claim to use it twice a week, and 4 users claiming to use it daily. On submission of the application, an owner-occupier evidence form was completed by Mr. Limer. He stated that the path was obstructed by vegetation and garden waste deposited by residents on Ox Pasture. He refused the path being public, and although he acknowledges that the path has existed for 20 plus years, he states that it has not been used for this period of time. Also, a Mr Balcock was identified as a landowner and a response was received advising that the alleged route was a private footpath as described in a conveyance of July 1931. It was advised that there has never been a need to erect a private footpath signs as the route is not used by the public at large. Balcock and Purcell solicitors act for the late Mr Balcock and his estate. There was correspondence between Chadderton Parish Council and Balcock and Purcell solicitors regarding the Parish Council buying the path from the Balcock estate, but the executors of the estate stated that they did not wish to sell the land. This was back in December 1999. We have also received comments from the Secretary of the Staffordshire Moorlands branch of the Ramblers Association, who said that they had personal knowledge of the footpath and they could see the benefits gained from putting the path on the definitive map. The Peak and Northern Footpath Society indicated that it had no evidence to submit either in support or against the application. The Leakin District Footpath Preservation and Ramblers Group responded stating that this was a well-used and useful path to the local school and would indeed benefit the community and walkers by being put on the definitive map. We also received a response from Staffordshire Moorlands District Council, who stated that the Council's Planning Committee resolved that the County Council should be urged to make an order amending the definitive map by giving footpath status to the alleged route. So under Section 31 of the Highways Act, this sets out the test that must be satisfied under statute for a way to become a public highway through usage by the public. It is clear from the available user evidence that there has been no interruptions to use of the alleged way, and therefore the date of challenge is taken from when the application was made in 1995. For 14 of the 24 users, this uninterrupted use of the alleged way has been for over the 20-year period. There is no evidence that any of the users have used force to use the route, and that usage has not been in secrecy. The path used by all the users is on the same line and there has been no indication that they have deviated from that line. The evidence forms do not support any contention that the users are drawn from a particular section of society or that use is limited to members of a particular area, although it is clear from the evidence that it isn't a route predominantly used by local people. While it is usual for the evidence to come from people who live in a locality, there is nothing to suggest that this is a prerequisite for use in this instance. As stated, the statutory test refers to use of over 20 years, and in the evidence submitted, there are 14 users who have used the path over that period of time. The remaining evidence suggests use continues throughout that time, but is for lesser periods. So neither the legislation nor the applicable case law set out a minimum level of use that is expected or required to support a claim that a route exists. The case law does suggest that the amount of usage should be such that it is enough to bring home to a reasonable landowner that the public are using a way and that it is as if it was a public highway, therefore as of right. In this case, the frequency of use does appear to be relatively high, given that 11 users claim to use the route every week. 3 users twice a week and 4 users state they use it daily. This usage should have been enough to bring it to a landowner's attention if they were present. However, there is conflicting evidence as one of the landowners, Mr Limer, has advised that the alleged route had rarely been used until 2 to 3 years prior to the application being made in 1995. And that particularly during the summer months, the route was overgrown with vegetation and therefore access was impossible to achieve. He also advises that residents from Oxpasture use the path to deposit garden waste, which also obstructs use of the way. Therefore, he argues that it has not been possible for the public to have used the way uninterrupted for 20 years. This is also supported by Mr Balcock. So therefore, the evidence from the landowners does bring into question the evidence from the users, but in light of the fact that 14 of the 24 users claim to have used the alleged route uninterrupted for 20 years would suggest that this is a route that has been accessible by members of the public. Also, the remaining users all claim to have used the route but for lesser periods of time. However, the user evidence should still be looked at with caution. So the remaining part of the Section 31 test considers whether the landowner has undertaken any action to rebut the statutory presumption of dedication. So this is often evidenced by ways of notices or obstructions to prevent people accessing or using the path. So in the case of R and Redcar and Cleveland, the court did say that for a presumption of dedication to be raised, it must be brought home to a landowner that a right is being asserted across his land. So therefore, it's how the matter would appear to a reasonable landowner who was present. If the use is such that it would go unnoticed by a reasonable landowner, so that is, it's used by so few and so sporadic that it would not be apparent the way it was being used, then it could be the case that no presumption of dedication would arise. So the landowners have intimated from their evidence that this was the case, as they argue that the route was not passable on foot, but they do concede that in the 2 to 3 years prior to the application being submitted, there was some evidence of use. However, no steps were taken to prevent usage of the way. If the user evidence is to be believed, the whole of the alleged route could be accessed uninterrupted for the 20-year period. So once a presumption of dedication is raised, then the burden lies with the owner to demonstrate by his actions that there was no intention to dedicate. In this case, there was no evidence that there have been any obstructions to prevent members of the public from using the alleged route. The landowners do advise that the route has always been a private path. However, it does not appear that any signs or notices have been erected to make members of the public aware that it was a private path, and therefore it could be argued that the landowner has not acted to show that there was no intention to dedicate the path. In considering whether a public highway of whatever description exists, the evidence also needs to be considered not only under statute but the common law. So under common law, the burden of proof is reversed, and that it is for the user to prove the owner dedicated the route, and the use does not have to be for 20 years. So the former can be inferred from the use, but as the judge in Nicholson and Secretary of State said, the more notorious it is, the more readily will dedication be inferred. So as already stated, there is conflicting evidence between the landowners and users as to the feasibility of using the route. But when considering the evidence as a whole, one could say that the use would have been obvious, that the owner must, if they were present, have known about it, and there was inferred dedication. So this is the two-stage test to consider in this case as to whether a modification order can be made. All the evidence must be evaluated and a conclusion reached whether on the balance of probabilities the alleged right subsists or the alleged right is reasonably alleged to subsist. Therefore, basically, once all the evidence has been considered, the first test that needs to be satisfied is whether the evidence shows that on the balance of probabilities the right-of-way subsists. And the second test is whether it can be reasonably alleged that the public right-of-way exists. So in this case, it is your officer's opinion that the evidence of use is sufficient to satisfy the test under Section 31 of the Highways Act when considered on the balance of probabilities. While there is conflicting evidence, there is no clear evidence that use of the route was prohibited and that users couldn't access the route. And in light of the number of users who have confirmed use of the route for the relevant 20-year period, this is supportive of uninterrupted use of the alleged way. In addition, there is no clear evidence from the landowners that there has been a clear intention not to dedicate the alleged route. So when the second part of the test is considered, that of reasonable allegation, this is also satisfied. Therefore, to conclude, based on the evidence just set out, it is your officer's opinion that the evidence shows that a public right-of-way with the status of footpath subsists.
Thank you, Hannah. And well done, and we look forward to the next presentation.
No, you won't. No, you won't. It's complicated.
All right. We've got Mike here, who's the local member. Would you like to say a few words?
Mr. Chairman, members of the Rights of Way panel, I've come here today because that route which has been determined, I used to go to school that way, so although I'm not on the list of users, I can assure you when I was a little boy that was one of the routes that I used to take a shortcut. But it started off being the vicar used to walk that route, I think in the 1930s, so it's been an awfully long time. And yeah, people did stick the rubbish over from Ox pasture. That's sadly is the case in many houses that back onto fields. I think the only obstruction I ever found was the cows in the field. I had a meeting with the Cheddleton Parish Council on Tuesday, and they gave me their full support to come along today. And although it was a previous parish clerk who put the application in 1993, they're fully supportive. And obviously the owners of that land, it's the executors now because the people have passed away. And they have tried several times to build on that land, and the parish council have made their intentions clear. They would like to buy that land as a piece of land for the village to use. So I'm here to support the parish council again, although it's a different parish council from the one that previously applied, but we're fully supportive of the recommendation by the officers, and for that I thank them very much.
Thank you, Mike. Obviously, this panel can't take into account uses of the land, but we can take into account the evidence in front of us, which has led to the recommendation. I'll start with David. Any thoughts?
Well, Chairman, I suppose really I start with a general thought that so often this committee has to consider footpaths that have not been clearly marked as public footpaths, and because of that are not in general usage. So if anyone does decide to explore a footpath that's not marked, they're probably going to be doing a trek through the jungle rather than having a pleasant walk along a marked footpath. Clearly the officer's recommendation is that we should approve this, and I would support that recommendation and move acceptance, Chairman.
Jill?
Yeah, thank you, Chair. Yeah, I've listened carefully and I agree that there is sufficient evidence and I would like to support it, so I second the motion. Thank you.
And as Chair, I agree as well, so the motion is passed. And can I say, it's actually a pleasure to have someone sat in one of the chairs who's actually walked that footpath as a young child, which presumably was 10 or 15 years ago, Mike. So, so thank you very much for coming and bringing the thoughts of the Parish Council. Before you go, David's got a word.
Well, only just to say on the reports that we've had this morning, just to thank the officers, because I think they've all been very clear, very precise, and we've been able to make clear decisions. And thank you particularly for the last report that we had, which I think took us very gently down the correct route. Thank you.
Right, thank you. Thank you. You've heard officers. Thank you, Mike. Thank you to Mick and his team for what's the reports we've had, which have been very clear this morning. We're moving on, please, to exclusion of the public. I've got to read this out, and that is that the public be excluded from the meeting for the following items of business, which involve the likely disclosure of exempt information as defined in the paragraph of Part 1 of Schedule 12A, as amended, of the Local Government Act 1972 indicated below. So we'll just wait for the webcast to be taken off before we move on to that.